Hello friends, this is Dr. Sumiti Ahuja and I am Assistant Professor from Faculty of Law, University of Delhi. Essential idea upon which the doctrine of frustration of contract is based is impossibility of performance of the contract. Now this, you will see that many places or in many previous judgments it has been mentioned whether exactly it is or for that matter there is this landmark judgment of Satyabrata Ghosh versus Mugniram Bangar. So these judgments, they have highlighted the point that impossibility and frustration are often used as interchangeable expressions, though under the Indian law section 56 which governs this aspect, we refer to it as, or it mentions impossibility, right? It becomes impossible to be performed, whereas the English law identifies it as doctrine of frustration. Changed circumstances make the performance of the contract impossible and parties are absolved, that is they are relieved from further performance of it as they did not promise to perform an impossibility. They did not promise to perform an impossibility. We have discussed what exactly do we mean by frustration, we mean by supervening impossibility. Now we have to see what is the effect of frustration. So fine, the performance has become impossible, but now what? What will be the fate of that contract now, and what will be the if I may say, the effect of such frustration? Parties are not required to resign the contract as the obligations of the parties get terminated immediately after contract is frustrated. Now in case of, in the previous mode of discharge, that was by mutual agreement or mutual consent, we just saw that it stated that a contract is coming to an end or is being terminated mutually, that is both the parties have collectively mutually decided that they would not be, no need to perform the obligations now. They have mutually decided themselves to terminate it. But effect of frustration is that there is no need for the parties to do anything. The situation is such, the circumstance is such that automatically if the act becomes impossible to be performed, the two parties are absolved or relieved from their respective liabilities or obligations and the contract gets terminated immediately. Further obligations are discharged. Frustration should not be, this is an important point, frustration shouldn't be due to act of party to the contract, that is self-induced, because when we say supervening impossibility, we are basically highlighting that something of such a nature happened which was beyond the control of the two parties. Parties had nothing to do with it. Whatever happened, they could not have done anything to control it, because if they could have stopped that event from taking place which made the performance impossible, then in such a case they cannot pray, or that party cannot pray impossibility, because it was self-induced frustration or self-induced impossibility. Now section 65 is important when we talk about void contracts, or what will be the effect of a void contract. So if I may say, section 56 part 2 can be read with section 65. So it says when an agreement is discovered to be void or when a contract becomes void, right. So we are referring to part 1 also, and we are referring to the void agreements as well. So when an agreement is discovered to be void or when a contract becomes void, part 2. Any person who has received any advantage under such agreement or contract is bound to restore it. We are talking about restitution here. Remember, we had made a mention to this section, or we had referred to this section under the topic of capacity to contract when we were discussing the judgment of Mohri Bibi versus Dharmadas Ghosh. So it says or to make compensation for it to the person from whom he received it. So if a contract becomes void due to some supervening impossibility coming into picture, then in that particular situation now, if one of the parties, because before the performance could take place, the contract has become impossible to be performed now, the obligations are not performable now, then in such a situation, if either of the party had received any kind of benefit, the court will ask the party, that particular party, to return that or to restore it back to the other party.